Greetings, friends of liberty. When we Londoners, here in the late 18th century, think of the maintenance of public order and the prevention of crime, I must say we are encouraged at the steady improvements made throughout this century. At its beginning, the citizenry at large was expected to help apprehend thieves and criminals on the street if they saw crimes committed or if victims requested their assistance by raising a hue and cry. But perhaps understandably, such general public aid has shifted to a more professional employment of deputies in the place of individual householders and watchmen to patrol the city during the night and constables during the day. All this was enabled by the Watch Act of 1730, which taxed the citizenry to create these regular patrols. Other improvements have been in 1720, £100 bounties offered for the apprehension of and conviction of highwaymen, and yet another, the establishment in 1749 of the so-called Bow Street Runners, who specialize in investigating crimes and finding and apprehending the perpetrators. All these steps portend an ever-increasing proficiency in the achievement of justice and the maintenance of order in London and elsewhere. Now, if we turn to the issue and subject of policing in your own 21st century in America, we find, quite extraordinarily, that in a country so very far advanced, nonetheless, an unexpected, retrograde, and sometimes astonishing inability of your society to police the police themselves. In Shielded, How Police Became Untouchable, longtime litigator and UCLA legal scholar Joanna Schwartz documents both the obvious and subtle ways in which American society allows its police forces to at times literally get away with murder and then deliberately not punish it. Her modus operandi throughout is to present egregious examples, illustrating through these often astonishing cases the legal principles and traditions maintaining many crucial aspects of the law. Let's follow her through a number of important instances as she applies her method. Case number 1, Henri Norris. In Atlanta, Georgia, in February of 2018, a squad of about 25 police officers executing a warrant to arrest a drug dealer convened first at a briefing room in a sheriff's office. Out of the 25, only one officer read the actual warrant, and even he, the captain, didn't bother to read it through. Otherwise, would have later recognized that they headed for the wrong address. Not knocking on the door like the ruffians they were, they used grenades and rams to gain access to 3 entrances. Of course, being clueless about the age of the suspect, because no one had read the warrant, they failed to see that the 78-year-old man was completely unlike the desired drug dealer. Despite the fact that Henri had a pacemaker and had had a heart bypass, they made him lie on the floor, causing him heart pain. Taking him outside, the cops finally realized their mistake, so all shut off their body cameras. We wouldn't want to record any more potentially inculpatory evidence now, would we? What were the options available to Henri and his family to punish the officers? A. Conviction in prison, though only in 2% of such cases, since usually prosecutors won't prosecute and juries convict if prison is the result. B. They being disciplined or fired, but this too rarely happens, since internal departmental investigations are often badly done or incomplete. C. Finally, suing the officers with possible monetary compensation. But success here, though more likely, is also rare. One of the main reasons why is the set of legal doctrines called qualified immunity. As Schwartz defines it, qualified immunity is a defense created by the Supreme Court that protects officers
from being sued for money damages, even if they have violated the Constitution, unless they have violated clearly established law. And what previously established law precisely? Law which recognizes nearly identical conduct. In other words, the policeman has to have violated the Constitution in precisely that same way. So for Henri Norris, the court recognized that his Fourth Amendment right to unreasonable searches was violated, and even that a very similar case had been previously judged in the victim's favor, but since that previous decision hadn't been published, and thus made public, he couldn't win his case. And oddly, the court refused to publish this case too. So bizarrely, those officers in the future can receive qualified immunity too. Case number 2, Alonzo Grant. Alonzo, a Syracuse, New York delivery driver and sawmill worker, actually called the police himself when his daughter started arguing intensely with a neighbor. But when the police arrived, the two had already stopped arguing and had gone back to their respective homes. However, the police, though told by Alonzo's wife that the trouble was past, nonetheless entered his dwelling without saying anything, and seeing Alonzo there, ordered him outside. When he came outside and his screen door slammed, the two officers grabbed him, swung him over the railing and onto the ground, and proceeded to beat him, eventually handcuffing him and sending him to the hospital in an ambulance. Furthermore, he was charged with resisting arrest, disorderly conduct, and harassing a police officer. Injuries included a broken nose, a concussion, a permanently injured left arm, a herniated disc, constant headaches, and recurring mental slowness. An experienced lawyer friend, seeing Alonzo after he was released from the hospital, called one of the best civil rights lawyers in the country, Charles Bonner. Would he take the case? Lawyers often don't, since A, people assaulted by the police rarely have the money to pay for a lawyer themselves. B, injury settlements often require waiving the lawyer's ability to recover attorney's fees. And C, judges, assuming padding of the fee, often give the final fee a huge haircut. But Charles Bonner nonetheless took the case and then worked on it for 4 years, totaling 2,500 hours, flying back and forth across the country from his home in San Francisco. He first got the bogus charges dismissed, then showed that the cops had lied when their internal affairs department had investigated, and finally, $1 million settlement for Alonzo. What did he get for himself for the 4 years and 2,500 hours? About $500,000, the judge reducing the desired fee of $1.5 million by 2/3. Of course, if he had lost, as often happens, it would have been pro bono. Case number 3, Tony Timpa. Tony, an executive having a schizophrenic episode and having taken some cocaine, was killed by Dallas police in circumstances similar to George Floyd's, by police officers sitting on him, their combined weight totaling over 300 pounds. He complaining as a result that he was going to die, then going limp and dying. The officers, both before and after he had died, joked around, and their department told his mother many false stories, such as that he had had a heart attack before the police arrived. The paramedics, too, refused to say anything. She finally discovered from a reporter that he had been handcuffed as he was dying, and also the police had worn body cameras. A prime difficulty in this, as other cases, was the catch-22 that there wasn't enough evidence to show to a judge to convince him that the complaint should be escalated to a charge, and thus that legal discovery should begin. But that dearth of evidence only existed because the Texas police refused to release the video footage and other relevant info. Fortunately, Jeff Henley, his mother's lawyer, was able to convince a judge to start discovery by forcing the city of Dallas to release names of the officers and their body cam videos by filing for public records requests and then suing the city in a separate lawsuit for failing to respond to those requests. Subsequently, a grand jury indicted 3 of the officers, but the district attorney dropped the charges, and the Dallas Police Department gave only a written reprimand to the officers and sent them back to work. Finally, in 2023, given the focus on the similar case of George Floyd, a measure of justice was granted and Timpa's son was awarded about $1 million. But Tony's estate was granted nothing, and because of the doctrine of qualified immunity, nothing happened to the officers. Case number 4, Andrew Scott. Scott, sitting in his living room late at night in his pajamas in July 2012, after coming home from his job at a pizzeria in Florida, heard a loud knocking and banging at his door. Behind his door was Police Deputy Richard Sylvester looking for a man on a motorcycle, possibly guilty of assault, who had disappeared into the apartment complex. Scott, owning a weapon and pointing it to the ground, then opened the door, whereupon the officer shot him 6 times, dead. In this chapter, Schwartz delves into the origins of the Fourth Amendment, incorporated into the Constitution precisely because of the similar habits of British officials and soldiers during colonial times. Some of the questions raised by this case are: A, do the police need to announce who they are? B, do they need a warrant to search a dwelling? And C, are they allowed to shoot a gun owner who isn't pointing his weapon at them? In the end, a state court refused to rehear the case, with the Supreme Court declining as well. Case number 5, George Floyd. Interesting it was how the city of Minneapolis, the municipality under which George died, never bothered to use qualified immunity, immediately giving the family a $27 million payout. How very different from Tony Timpa, whose mother and estate got nothing. As Schwartz says, officers have killed people in Alabama, Florida, Georgia, Illinois, Missouri, New Hampshire, Oklahoma, and Texas in just the way Chauvin killed Floyd, with a knee on their back or neck, but have had their civil rights lawsuits dismissed on qualified immunity grounds. Case number 6, the entire Vallejo, California Police Department. Highly recommended it is never to pass across the city lines into Vallejo, where, as of August 2019, nearly 40% of the approximately 100 officers had been involved in at least one shooting. The gratuitous use of violence by officers on unarmed and non-threatening persons is common. Here are some instances. Number 1, putting a person in a carotid restraint for so long that the blood vessels in both eyes popped and he passed out. They also slammed his head into the concrete and tased him while he was in handcuffs for good measure. Number 2, attacking a bystander watching an arrest, one officer shooting him in the groin, another tasing him, and a third beating him while prone. Number 3, shooting and killing Sean Monterosa, a 20-year-old Latino man who was kneeling with his hands raised in a parking lot. As a result of this unchecked violence, this police force itself is responsible for 25 or 30% of total homicides in Vallejo. Case number 7, Rob Lisi. Here a homeless man, Rob Lisi, invited, according to his own testimony, into an Orlando, Florida bar and treated by a stranger to drinks, was left with a $60 tab when the stranger absconded. The bartender, refusing Lisa's offer to work to pay it off, called the police. The officer responding, Peter Delio, ignoring Lisa's request to give him a minute getting into the squad car, giving his bad knees and drunken state, instead kicked Lise in the stomach, sending his body into the back seat. At the station, Delio entered Lisa's cell and kicked Lise in the stomach, causing him intense pain and loss of consciousness. Transported to a hospital, Lise needed to have his spleen removed. the resulting medical bills over the next 2 weeks totaling close to $90,000. As a result of the loss of his spleen, the rest of his life was changed, with his health deteriorating and making full-time employment difficult. This case was only one of the 7% that on average go to trial. Nonetheless, a jury still has to convict, and this happens in only 15% of these. In this case, the jury, likely sympathetic to the men in blue, agreed with Delio's guilt, but gave Lease not a penny in damages. Turning finally to remedies, we might firstly imagine that suing enough of these rogue officers would, as time went by, inspire them with a greater fear of the law. But again, as in so many aspects of treating police brutality, while this logic is impeccable, the trouble is the extreme rarity of actual individual payments, with a total of less than 1% of the total monies, 0.02% to be precise, being paid by the officers themselves. The taxpayer pays the rest. As Schwartz summarizes, officers were more likely to be struck by lightning than pay anything from their pockets in a police misconduct case. So we see that, number one, most police officers don't have anywhere near the assets needed to substantially pay off the settlement. Number two, if the municipality pays, the money usually comes out of other areas of the budget. As Schwartz says, her research showed that Broward County, Florida, Columbus, Ohio, and Boston, Massachusetts underfunded their police department litigation budget and then took the extra that they needed from other parts of the city budgets. Number three, in many cases, when an officer had a lawsuit against him, a record of it isn't even included in his personnel files. And so departments in many cases apparently remain unaware of the result of lawsuits and don't act on that information, despite, in New York City, 2 successive comptrollers recommending they do exactly that. In conclusion, this book is superb, perhaps the best treatment for the educated layman on the judicial treatment of police brutality. I'd give it an A, A-, the only slight quibble being that I would have liked some estimate for what percentage of overall police actions could be thus characterized, and whether it's getting worse or better. A little digression as well on the power of public sector police unions to protect their privileged members from the consequences of their actions, which is certainly a significant factor, would also have been welcome. Very happy to relate that the reputation of the 18th century English police is constantly growing, so much so that Robert Peel, the 5-year-old son of a friend, has already told all and sundry he wants to be a policeman when he grows up. I bid you well and remain the Scarlet Pimpernel.